Hello, welcome to Legalology 268. If you are new here, please stick around. You're going to learn so much. If you've already been subscribed to this channel, thank you for your love and support. It means the world to me. As always, I'm Susan, and today's topic, we are going to be talking about a summary judgment. If you are doing the bar training course or the LPC, this is a topic that you need to be familiar with. So please stick around. Let's not waste any more time. Let's get into it. So, what exactly is a summary judgment? A summary judgment is a procedure which the court uses to decide if a particular claim or issue should come to an end without the use of a trial. The court may come to this decision if it considers that one party cannot realistically succeed in bringing the claim, or the other party cannot successfully defend the claim, and there is no other reason to conduct a trial on the matter. When you think of a summary judgment, I want you to look at it this way. Think of a summary judgment as the court's way of deciding not to waste time and other resources to deal with an issue which otherwise would just go nowhere. And that's the reason why a summary judgment is issued, because the court would have realized that either the person who brings the claim cannot succeed, or the person who is trying to defend the claim cannot succeed, and the court just cannot see any other way or any other reason for that matter why this matter should be disposed of at a trial. Now, let's talk about the test that the court uses in order to determine if a summary judgment should be issued. In your civil procedure rules, the summary judgment is located under Part 24, and specifically 24.2. And it says, the court may give summary judgment against a claimant or defendant on the whole of a claim or on a particular issue if A, it considers that 1, that claimant has no real prospect of succeeding on the claim or issue, or 2, that defendant has no prospect of successfully defending the claim or issue, and B, there is no other compelling reason why the case or issue should be disposed of at a trial. It is very important that you learn this rule, because that's the only way you're going to understand summary judgment. You need to learn this particular rule. And when you learn the rule, I want you to pay attention to some key phrases. For instance, in the opening sentence, it mentions that the summary judgment could be given against the whole of a claim or on a particular issue. That is to say that the court may decide to give a summary judgment on a whole claim, or a particular claim may have several issues, and the court may decide only to give a summary judgment on maybe 1 or 2 issues depending. So it's very important that you understand that a summary judgment may be against the whole claim, or it may be on a particular issue, which means that the other issues which form part of the claim could actually end up going to trial. I am now going to discuss with you, or rather I'm going to highlight some points about a summary judgment that you need to always be aware of. Firstly, the CPR Rule 24.2, which deals with summary judgment, is supplemented by Practice Direction 24. So you need also to read that in addition to reading the actual rule, and you need to make sure that you're familiar with both. Secondly, a respondent to an application for summary judgment, meaning the person who is defending it, must show that their case has a real prospect of success. What do we mean by real prospect of success? And remember, we were just talking about that phrase earlier. Well, for one thing, according to case law, it should not be false, fanciful, or imaginary. And it means that your case should be more than merely arguable. There should be more to it, more meat on the bones, if you will. And I've listed some cases there that you can check out. And please, when you read the CPR, the rule, please read the editorials at the bottom of the page, because that's where a lot of information is found. A lot of cases are mentioned there, and there are other issues, other points that are highlighted in the editorials in the small print at the bottom of the page. And that's actually where these cases came from. And you can read these cases and have an understanding as to what it is meant by real prospect of success. Another very important point: a summary judgment is not to be used to conduct a mini trial. That is not what a summary judgment is for. Remember, you have to show real prospect of success. Okay? Real prospect of success, meaning there is none. Whether bringing the claim or defending the claim, and there's no compelling reason. That's the test. That is the test. If you are going into complicated issues and arguments and scenarios, then a summary judgment has already gone out of the window, because now the court would definitely have to look at everything and say, well, no, we can't dispose of this matter. There are too many issues here. These issues have much merit. We need to actually conduct a trial to look into it. That's the opposite of what a summary judgment is about. So please bear that in mind. Now, in relation to a defendant, a summary judgment is not given in these circumstances. In relation to possession of a defendant's home, for example, if mortgage has not been paid, in relation to admiralty claims in rem, and in relation to a counterclaim if there is a set-off situation. In those instances, a summary judgment is not given against a defendant. And we are moving right along. But before I go any further, do me a favor. If you are learning about a summary judgment, if this topic is a little clearer to you, please just hit the like button. Show some love and appreciation. I would love it so much. Let's continue. Other points to note about a summary judgment. A defendant can apply for summary judgment at any time once proceedings have commenced, while the claimant can apply after the defendant has filed acknowledgement of service or a defense. Let's look at the time frames. The defendant, or in this case the respondent, must be given at least 14 clear days notice of the hearing date. The defendant would file and serve on the claimant, who in this case would be the applicant, written evidence in response at least 7 clear days before the hearing. The claimant files and serves written evidence in reply at least 3 clear days before the hearing. Please, students, ensure that you have the days clear. Make sure you know who is to do what and when. That's very important when you are dealing with a summary judgment application. And also, if you are going to be tested on this topic, you need to know the time frames in which certain actions can be done. If a defendant counterclaims an amount, or a set-off amount rather, which is less than the value of the claim, the claimant can claim summary judgment for the balance because there's a real prospect of succeeding in the claim. Remember, in a case where you have a set-off situation occurring, Basically, what it means is that the defendant has a defense to the claim that is brought by the claimant. And here's a good example. Let's say the claimant claims that the defendant owes him £20,000. And in his defense, the defendant counterclaims that the claimant owes him £10,000. There is an outstanding balance, obviously, of £10,000 because the starting figure was £20,000. What that means is that the claimant can still claim summary judgment for that outstanding balance of £10,000. In cases, however, where a check has been dishonored by the defendant, the defense of set-off is not available, and therefore the claimant can claim summary judgment for the full amount. And of course, if the claimant is able to satisfy the test for summary judgment, then obviously the claim will be successful. The summary judgment application has been made. Both sides have made their submissions as to why or why not a summary judgment should be granted. What now are the possible outcomes from a summary judgment application? Well, let's take a look at them. For one thing, the court may decide to grant the claimant the summary judgment, which means the claimant wins. And of course, if you're the claimant, you're happy for that. Or the court may decide that the claimant did not satisfy the test and decides to strike out the claim or dismiss the claim, in which case the summary judgment is not granted and the defendant wins. The court may also decide to dismiss the application. And in a case like this, it means that the matter is going to continue to a full trial. The court may also decide to issue a conditional order, and it would do so if it appears to the court that the claim or the defense or the issue may succeed, but it's improbable. And so what that means now is that the court is going to require the party to do something, and it may either be to pay a sum of money into the court or to take a specified step or risk dismissal of the claim or strikeout of the statement of case. The court may also issue an order which deals with costs. These are all some of the possible outcomes of a summary judgment application. If you are still watching this video at this point, it simply tells me that you have been enjoying learning about summary judgment. I thank you so much for watching. Please, if you have not yet subscribed to this channel, what are you waiting for? Come on, click the subscribe button. If you haven't liked this video, please give it a thumbs up because we want other people to see it so they can also learn about a summary judgment. If you also want to follow us on Instagram, please check us out at Legalology268. Once again, thanks for watching and see you in the next one.